recording. And tonight we have the People versus Pantone with presiding Justice Kyle Durante. Justice Durante, let me turn the controls over to you. Hold on. Here we go. Okay, Justice Durante, it's your show.
Okay, so we should start with a poll. Who believes that the appellate division should be reversed? Anybody think the appellate division should be reversed? All right, Tiffany. Jeff. All right, so it's just Tiffany and Jeff. So why don't we start with you guys since you're, and Alyssa. All right, so since you guys are in the minority, let's start with you guys. So Tiffany, you can go first and explain why you believe they should be reversed.
Okay, so I think it should be reversed because the facts are similar to the Sparkle Daniel, Sparkle's co-defendant. I believe the person or the defendant in this case should have been read her Miranda rights as soon as she was taken into custody, which I believe happened in her house. And she was arrested under false pretenses because the warrant that they had was actually vacated, I believe the record said. So they took her on an invalid warrant, took her under arrest, took her to get interrogated, and they asked her the same questions that they asked Sparkle Daniel. And it was basically the same situation. It looked like it was an investigation tactic. So under People v. Miranda, she should have been read her Miranda rights as soon as she was in custodial, so as soon as it became a custodial interrogation.
Okay, Jeff?
I mean, I think Tiffany put it great right there. She absolutely should have been read her Miranda rights. What's the point of a Miranda right if you're under arrest and they're not read to you? The whole point is to read you your rights before, at the exact moment that you are arrested. And that didn't happen here.
Okay, Alyssa?
Yes, I completely agree with Tiffany and Jeff, just because it's essentially the same reasoning as Sparkle Daniel, it parallel to that. And we really come down to the question of when does custody begin? And I feel that, she should have been read the rights immediately before she was questioned. So I feel that that's the reasoning.
Okay. I think before we actually get into the substantive areas, we should go through the procedural areas, because if we can't agree through those, we'll never make it to the substantive areas. So the first main issue would be, did the defense counsel preserve the error? What is anyone's opinions on that? Due to suppression hearings. Okay, well, I'll give you my opinion on it then. I think that the defense counsel did reserve the error because it was a joint suppression hearing. And in a joint suppression hearing, as long as one counsel makes the argument, it applies for both. At least under the Federal Rules of Evidence, it does. I'm not 100% sure about New York. But for that reason, I think that he did reserve the error. Tiffany?
I agree with you, Kyle. I think the issue was preserved. I believe there was an issue with the language of the like how they preserved it. They didn't, I don't think, outright preserved it. They just used, I have to check the record. They just used different language, but the gist is still the same. They preserved the appeal, so I don't see an issue with that.
Okay, so is the majority right now that they did preserve or didn't preserve? So if you believe they did preserve, raise your hand. All right, so still a minority. So let's go with the majority right now and see what their opinions are. Let's say, Catherine?
Now, you said the federal rules of evidence say that a co-defendant can, if they bring up the issue on their side, it extends to the other co-defendant. I wasn't aware of that. I thought it had to be brought up on a case-by-case basis. And
normally when there's a joint hearing, if there's two attorneys, one for each defendant, as long as they're both making the objection and one attorney makes the argument for the basis of the objection, it encompasses both.
Okay. Then I would switch over. If I didn't look that up, so if that is the case, I would switch over and agree.
Okay, so we got Tiffany, Jeff, and you that agree that it is preserved. Melissa? Melissa, can you hear me? She's unmuted. All right, so we'll go back to her. Alyssa?
I'm still really not too sure on this aspect. I'm kind of on the fence with it, so I'm not too sure yet. I kind of agree with the, I don't know. I'm still trying to figure it out.
What are you unsure about with it?
Well, I don't know. I mean, I'm not too sure yet. I think once we kind of discuss it a little bit more, maybe I can make a better decision on it. I'm just still a little confused about the evidence aspect that you mentioned.
Okay. Chris?
Yeah, I might not be able to weigh in too much right now either because I'm on the fence with this issue as well.
Okay, so let's go to the majority then and let's see what their arguments are for in favor of it. Tiffany, go ahead.
In favor of upholding, or I'm sorry.
In favor of stating that the error was preserved by defense counsel.
Okay, so I'm trying to find the language. It's in the appellant's brief. I'm pulling it up. My iPad's like freezing everything. Okay, so the issue was preserved by counsel. It says on page 45 of the appellant's brief. The joint suppression hearing, co-counsel first vigorously argued the Miranda violation and lack of attenuation. And the court discredited the statements that they used, or the language that they used to preserve the hearing. And I think that, I don't know if preserving form over substance is like I'm using it in the right context, but I feel like they're preserving form over substance. I believe the appellants did preserve the appeal and they used the language that they used, but I feel like the court discredited that language because they had I don't want to say agenda, but I felt like they wanted to rule that way. And they mentioned judicial credibility. They don't want to overturn their credibility because of this issue. So I didn't agree with that.
Okay. Catherine?
I was just reading back into the people's brief, and how do we overcome People v. Buckley?
What does that case hold? I just don't have it in front of me.
The defendant cannot rely on the request of a co-defendant to preserve and the claim, charge, or error. Defendant's attorney neither joined in co-defendant's motion for severance nor made his own motion and therefore has not preserved the issue.
What page are you on? Of what brief?
The People's brief, page 32.
What case was it?
People v. Buckley's. Am I on the right page?
Tiffany, what's your opinion on this?
And then they go into People v. McGee as well, which I think holds relatively the same thing in the next sentence.
I'm on page 51 and 54 of the appellant's brief, and the attorney here, I feel, made a valid argument. He said that just because the appellant's attorney didn't articulate it as specifically as the people did, or as the co-defendant's attorney did, doesn't make it less valid. It's typically it's basically the same argument. It's just different language. So I feel that it is what it is. It's the same language. It's just different court, different judge, I believe, and they're ruling a different way, but it's the same facts. It's the same arguments from different attorneys, worded differently, but it's just, the substance is the same. And regardless, they basically ignored the substance and still went ahead and said that the issue wasn't preserved.
I agree with Tiffany, because I believe that if we throw everything out saying that you have to say exactly in this manner, you're unfairly prejudicing a number of defendants. As long as they made an objection with the gist of the proper objection, I don't see an issue in why we should hold that it's not preserved.
I guess I'm just struggling with the fact that they didn't bring up not even the words pre-custodial, but just, it seems like the initial defense was the arrest itself, and they didn't really focus in on the photograph that was presented until after they lost. So how do you feel about that?
I feel like more of the issue is not centered on the photograph as much as so much of it is that it's a continuous conversation. It's the continuous interrogation that we're really focusing on, not so much of the photograph. Because if we can consider a continuous interrogation, anything, it can be held that it is, they were not Mirandized because they were not Mirandized at the beginning of the interrogation. It's very simple to the Sparkle case that we dealt with the other day. Then. Tiffany?
To add to what you were saying, Kyle, I feel like this case was really confusing because it was similar to the Sparkle case. And I actually, when I first began reading it, I thought this is really messed up because for the Sparkle case, I was like, listen, she should have been Mirandized. This is what happened. But this case, it was harder for me to get to that conclusion because she was arrested in home. And it really, I don't know how long, I don't think it stated how long the car ride was. I don't remember. But she was taken in on a warrant. It was an invalid warrant, but she went to the same procedures, but I believe she was read her Miranda warnings before she incriminated herself. So.
Well, then that brings up the issue with the photo because the prosecutor used the photo as incriminating evidence in trial. Exactly.
And then also the question that was posed to her, do you know why you're here? Similar to Sparkle Daniel. That could really be where the interrogation began. I believe that is where the interrogation began, and she began to be in custody when she was arrested in her home. So that's why I was able to get to my conclusion.
I have the same reasoning as you do for the reason that I believe it should be reversed. But before we can get to that, we have to get through the procedural issue of whether it's preserved. If it's not preserved, we don't have the ability to hear the issue. Jeff, you raised your hand and then took it back down.
Yeah, I was going to talk about how in the summation they used the fact that she was crying, which happened pre-Miranda, and I think that's where this whole issue came from, but it had nothing to do with the procedural.
Okay. Alyssa, has this helped sway you with the procedural issue?
Yes, I definitely agree with Tiffany and you on that for sure.
Okay.
Based on your reasoning.
Chris?
Oh crap, where did my thing go?
I'm not fully persuaded, I guess.
What's your dilemma with then? What part of it?
I don't know exactly. I guess, I see obviously the similarities between this case and the Sparkle Daniels case, but at the same time, as we mentioned, there are big differences. So,
Well, what's your issue with the procedural issue? Let's get through that first, and then we'll get to substantive.
oh, well, as far as that, I'm good with that. I agree with you.
You agree that it has been preserved?
Yes.
Okay. Catherine, you're still on board with us with being preserved, correct?
Yes.
Okay. Caitlin?
Sorry, I was having technological issues, so I missed the first part of class about you guys talking about it being preserved. So if I could just have like a quick, like 2-second brief, what I think.
Sure. Right now we're just trying to get through the procedural issues before we move into the substantive issues. So right now we're discussing of whether or not the defense counsel preserved the error for the appeal. Because he made the objection was made really by the other co-counsel, and he did not specifically state the reason for his objection. It was kind of in an unorthodox language that he objected.
Okay, for that one, yeah, I think that they preserved.
For what reasoning?
Sorry, I have. None of my technology is working today. This is good. Can you just like come back to me? Give me like 2 minutes. I'm so sorry.
Sure, you're fine. You, son?
You ask about procedural issue.
Yeah, the preservation issue.
I think, I'm not sure, but I think preserved. I'm taking a look at defendant's reply brief. Actually, I really focused on kind of substantive one. It's very similar to Daniel, as I told you before. So I actually, what I'm thinking is first statement tainted and kind of detective kind of lied, and in addition to that, invalid warrant. So I really focused on that. So I'm kind of lost regarding a procedural one. Sorry.
Okay. Do you think that the issue has been preserved, though, from Tiffany's, mine, and Jeff's argument?
Yeah. Actually, I undecided yet, but now I'm for Panton, actually.
Okay.
You know what I mean?
Melissa?
Can you hear me?
Yep.
Okay. Well, I've been a little bit confused here, trying to figure out whether it was preserved or not. But based on what you guys been discussing about what the objection that the lawyer made, it looks like it was preserved.
Preserved? Okay. Okay, then before we move on to the other substantive issues, there's still one more procedural issue. Whether or not this is a mixed question of fact or law. The same question from Sparkle. I believe that if, based on the holding we had on Tuesday, it would apply the same way here. It's basically the same fact pattern, and we ruled before that once someone's put into custody that they should be Mirandized as a matter of law. And it's the same situation here because she was put into custody once she was arrested from her home. Caitlin?
I just have one question with regards to the arrest, because I know, like, yes, she was brought in on a warrant, but I know that she wasn't technically put in handcuffs, and I know with the Sparkle Daniel case, like, that's what we were really discussing, and I was also confused. Can we use the, I guess, majority decision we made in Sparkle Daniel to help us with this, since they are so similar?
That's a good
like,
question. She said yes.
Okay. then I would have to agree with you then that we should do a matter of law.
In that situation, I think that there are previous decisions really controlling precedent on this because it's pretty much the same issue, but we can still discuss it. Someone else raised their hand, but you took it down. All right, so who believes that this is not a mixed question and we do have jurisdiction to hear this issue, following the same reasoning we had from Tuesday?
Why can't I raise my hand? I can't raise my hand for some reason.
Catherine, I'll discount you.
Yes, thank you.
All right, so Chris, you don't agree. Chris, are you there?
Yeah. Well,
Okay.
well, I'm not sure what the question is, but I agree with the logic we were going with on Tuesday.
Okay, well, it's the same. Well, the same question arose here, whether it's a mixed question of fact or law.
Right.
And that's really the issue we have to get through before we can move to the substantive issue.
Right.
And the main argument is that our precedent from Tuesday should be controlling in this case because it is the same fact pattern pretty much. She was put into custody, thus it should begin at that point as a matter of law.
Yeah, I agree.
Okay. You, Sam?
I think it's mixed questions of law and fact.
You think it's mixed?
I think so, because of very similar fact, and as I told you before, in addition to that, invalid warrants as well. So I think her statement is tainted.
Okay. Well, why don't we do what we did the other day? We'll come back to this issue at the end so we can at least move on to the substantive issues. So the first substantive issue that I've seen is, was the interrogation continuous? From the beginning of the interrogation through her crying, and then she was Mirandized, and then the information that was received from her afterwards. Catherine?
I don't think it was continuous. I think the period of her crying was enough time for it to be considered attenuated. Is that the right word? I think at that point in time, she knew what was going on. She was then read her rights. She then incriminated herself in that order. I think there was enough time where you can't consider it continuous.
Did you look at the factors, the same ones we applied the other day?
I did not, because I was out the other day, so I didn't get a chance to listen to your full discussion that you had.
Okay, they're the same factors that are used in these briefs.
Mm-hmm. I have those facts.
Did you apply those factors to the issue? Because I think when you apply those factors to the issue is when they're on page 41 of the appellant's brief.
Okay, let me go there.
All right, while you do that, I'm going to jump to Tiffany real quick. Tiff?
So I think I actually have I have a question, and then I'll answer your question first. But I think that it was continuous because applying the factors that we applied in the previous case, in the Sparkle Daniel case, like the length of the interrogation, whether she was moved from a different room, whether there was a break. I think there's a stronger argument here, actually, that there was no break, because unlike the Sparkle Daniel case, which Sparkle Daniel, she was given a meal, she was allowed to eat for 2 hours, the detective left, although, briefly. In this case, it says, the record reflects that they didn't leave at all. They were by her side the entire time. She didn't eat. She was arrested, taken to the police station, brought to, I believe, in a lineup room. They didn't leave her side, like Sparkle Daniel. And also, what else did I want to say? Not only did they not leave her side, but during the interview, the video interview, the detective sat by her. He removed, I believe there were like tissues there or toilet paper. He removed that from her. They were with her 100%. So unlike Sparkle Daniel, I think there's a stronger argument here that there really was no break and that it was continuous. Whereas in Sparkle Daniel, an argument could have been made that there was maybe a break, and I think we did get into this on Tuesday, that there was a substantial, or there was a possibility that the taint could have been dissipated by that break. Here, we don't have that.
Okay, you, Sun?
I just wanted to add to Tiffany's statement. Actually, based on the factor established in citing case, I don't remember the case name now. I guess Pullman. But here, same evening, in the same place, with the same officer by her side. So I think 4 or 5 factors were met for continuous chain of event. That's what I'm thinking.
I agree with you, because the other day we held that it was a continuous chain of events. And if, just like Tiffany said, and I think in this case, it's even more present that it's continuous than it was in the previous case. She
Right.
never left the room. She was always with the same person. She was never left alone. There was not a significant break. She was not allowed to eat, things like that.
Yeah.
Jeff?
Yeah, I was just going to go through the factors on page 41 and apply them to the facts and just show that it was continuous. The first factor, the time differential between the Miranda violation and the subsequent statement, was almost instant. I don't even think there was a time after, because whether the same police were present, they were. Whether there was a change in location or nature of the interrogation, neither of that is. There was no change, and the nature remained the same. And the circumstances of the violation, including the extent of improper questioning and whether the defendant had indicating a willingness to speak to police. And she did have a willingness, but it was almost as if it was coerced, because she just wanted to go home. And she was told if they meet with the judge, this will all be taken care of. So.
Do you see her crying as an interruption, though?
No, I think that's like natural. I mean, I personally wouldn't cry, but I'm sure someone could cry if they saw like a dead person picture in front of them, like slapped in front of you. Like, I don't think that's like an unreasonable reaction to have.
Do you think it was done purposely to elicit a statement out of her while she was, even though she wasn't Mirandized yet?
I mean, it was definitely a tactic to get something out of her, maybe to guilt her, and because they were essentially accusing her, so they wanted her to be like, "This is what you did," kind of thing.
What about the time? Because I know the other day we had a huge issue because like a lot of people argued that, they were just having small talk. But there was an 18-minute gap between when she began talking to them and when she was actually cried and then Mirandized. So with 18 minutes, you're way beyond small talk now, and now you're into an interrogation.
I don't think small talk exists with police. I think police are there to do their job, and their job was to find a murderer, not to be like, "Hey, how are you doing?" Like,
So you think the interrogation started immediately?
Absolutely. The minute the police, I think, takes you into custody is when they start questioning, and the defense used it, the prosecution used it in their summation.
Okay. Catherine?
I'm not convinced that the interrogation started when they showed the picture, because they could have showed a picture to her before they arrested her, and it wouldn't have meant the same thing as what you're claiming it does.
So when do you believe the interrogation started?
After she was Mirandized, when she knew what she was there for.
I disagree with you on this one, just because I believe it started just like Jeff did at the beginning, like when they sat down to talk. It's the same reasoning I actually had the other day, but I don't think you were here. You don't take somebody into an interrogation room to do nothing but you're going to interrogate them. Like, the person must perceive that they are being interrogated, and the officers know objectively that they are interrogating someone. You don't bring someone into an interrogation room, arrest them on a fake warrant and things like that, unless you are anticipating to interrogate them. In my opinion, the Miranda warning should have been given immediately. And especially officers know that they're required to give this. Why would they not just give the Miranda warning at the beginning to avoid this entire issue?
I see where you're coming from. But she didn't incriminate herself until after she was read her rights.
Not the prosecutor used the picture, which they said that her crying was incriminating in their summation to help further the verdict.
I don't think her crying incriminated her at all. I think she was scared because she saw a dead body on a picture. And she had the chance after she was Mirandized to not say a word, and she didn't.
See, the hard thing is with the picture and crying, I think if I'm remembering it correctly, it wasn't just like she cried because she was, in my opinion, just from the way I read it, that just because she was surprised at what she's seen, but it was like a deep sob. Like she knew there was more behind it than just, oh, I'm upset because I saw a dead person. In my opinion.
Even if she was crying because she knew she did it, she was still Mirandized before she gave anything up for herself. So I don't really have sympathy for that.
Okay. Tiffany?
I don't think she was Mirandized until after she started crying, and that's the issue I have here. And another issue I have is the fact that we have such conflicting facts in both cases. I mean, both of them turned on each other, and then they said that there was wine pouring down her throat and that she was tied with duct tape, when in fact that wasn't the case. She had, I believe it was telephone wires wrapped around her feet, and they did not find, it was either one or the other, scotch or wine. They did not find wine in her stomach, but they found scotch from social drinking in her stomach. And I'm really concerned that the police it's like they wanted to arrest these two girls, even though the story from MRS or Mr. Regent and his girlfriend, the granddaughter, was a lot more credible. It included social drinking. I believe it included the duct tape. It included facts that were more relevant to the case and that really happened, as opposed to here where these girls, I don't know why, the facts are so conflicting, and I'm concerned about that.
No, I agree with you. I think between the two briefs from this case and the two briefs from the other case, they're completely different facts in each brief. So, I mean, I think that is also an issue. Jeff?
Yeah, I have a question, I guess, for Catherine. When do you think she was arrested? Like when she was taken from her house, or when she was read her Miranda rights after the 18 minutes of interrogation?
I don't feel like they followed protocol in not putting the handcuffs on her. So I don't believe she was arrested. I believe she went willingly. She wasn't handcuffed.
If I'm not mistaken, did she say, like, don't put them on in front of my children? Did she say that? I don't.
Yeah, I think she did. But if they wanted to arrest her, they would have arrested her. I think they took that. And maybe that's not correct, but I don't think she was arrested at that point. What does everyone else think?
Catherine, do you see the issue with the arrest warrant, that they used a old expired arrest warrant as a pretext to get to her?
That does bother me, but I don't think the interrogation began at that point. And that was really the sole issue here.
Yeah. Okay. So you said you want to see what everybody else thought. So
Yes.
Tiff, your hand's raised.
I have two. I want to know, I think that she was placed in custody at her home, and she wasn't interrogated until she was asked, do you know why you're here? The same as Sparkle Daniel. But I want to know also, and I don't know if anybody else is concerned about this or picked this up, but the record reflects that she was Mirandized twice. So if you Mirandize somebody once already, why are you Mirandizing them again on camera to make it seem to me more credible? So I wanted people's thoughts on that. I didn't understand that.
I think that's actually common police practice. Once, if you're taking a statement of them where it's not being recorded and then it's being taken again later for the purposes of recording, I believe they're always Mirandized twice, just so it is on recording. I think that's standard practice because I've heard of that more than once. And it was also in the Sparkle case was the same thing. She was Mirandized, arguably before she spoke, and then she was Mirandized again before she gave the video. Caitlin?
I think, Catherine, I feel like I understand your argument, and I think that if we didn't do the Daniels case first and we did one of the civil cases first, I would probably be more leaning towards you. But I feel like with the facts in the case and us already discussing that one case, that they're so similar that you can't not, do the same thing with this case that you did with that one, if that makes any sense.
Alyssa?
Yeah, I feel that she was in custody once, they were at her house. So I feel that, the entire interrogation process was continuous on that.
Do you feel as though her crying in the middle interrupted the interrogation where it's no longer continuous?
Originally, I kind of thought that, the crying stopped it, but no.
Why?
I feel that once they really started, they brought her there for a reason. So it just fell into place that they just kept questioning her, and it was continuous.
Okay. Jeff?
I think to say that the crying stopped it is kind of ridiculous. It's like saying if I sneezed, it stopped it, or if I coughed. It could have just been like a natural reaction, and it shouldn't I'm sure tons of people cry when they get taken in by the police, especially if they know that they did something wrong. So for her to, I just don't see how this crying could have stopped anything.
But do you think the crying is incriminating?
Oh, yeah, and if it wasn't, the prosecution wouldn't have used it in their summation. Yeah, I don't... That's like the issue I have, is that the prosecution used it against her.
I agree. I think if the prosecution didn't use it, it would be less of an issue. But because they use it and it shows it is incriminating,
right.
Now that kind of proves that you have there was a continuous interrogation the entire time.
I don't know the phrase, if it walks like a duck or something.
And it sounds like a duck, it quacks like a duck, it is a duck, yeah.
Yeah, like that's what this interrogation was. Like she was, whether or not the arrest happened, like the police went to her house with the intent to arrest her, and they knew that they were trying to get a confession out of her.
Okay. Melissa, what's your opinion on this?
Well, I understand that she was deceived when they went to her house with a fake warrant. So from that moment, I understand that she was taken into custody. And the crying, I don't think that would be a break into the interrogation. I wouldn't consider that. She didn't change of environment. It was the same police officers. She didn't have a break. So basically, it's the same process.
Okay. Yusan?
Same, continuous chain of event.
Okay, so you agree with the majority, with that there was a continuous chain of events. And it was a continuous, and it should have been suppressed?
Yes.
Okay. Does anybody believe that it should not be suppressed? Besides Catherine? Everybody agrees that it should be suppressed except Catherine? Okay, Catherine. Then explain to me why you don't think it should be suppressed. I'm sorry.
I like to look at things in very simple terms. She didn't incriminate herself until after she was read her Miranda rights. She wasn't convicted because she was crying. She was convicted because the statement she gave after the fact that she was Mirandized. I don't feel the interrogation began until she knew what was going on when she was shown the picture. And she was Mirandized right after that.
Well, since she was put in custody, and she was told she was being put in custody because she had to go to the courthouse to deal with the judge.
But she was never put in handcuffs.
Because she asked not to.
Well, the police let her not be in handcuffs, so they didn't arrest her.
What do you think a reasonable person would think if they were placed in an interrogation room, though? And what's the subjective intent of the officer when placing them in that interrogation room?
But does that really matter?
It does.
Subjective intent?
The intent of it's really so much, not so much intent, but it's what the officer perceived is a factor that is in the case law. If an objective officer would believe that this person was being interrogated, then he should have given Miranda. So what would a reasonable officer believe if they went to someone's house with the incorrect warrant, took her from her home, placed her in an interrogation room?
I mean, I see where you're going with that, but they could use that practice to do questioning for witnesses the same way they would someone who they're interrogating. I don't know the practices of that particular police station.
Do they lie and say they have a warrant, though?
That I have an issue with, but that I feel separate. I feel it's separate. She was already there when she incriminated herself. So how she got there, I do have an issue with that. But she wasn't arrested. I don't think so.
Doesn't the record say that she was placed under arrest, though? I'm sorry, I'm attacking you, but you're the only person that's in the majority.
If it does, I have to go back to that. I'm going back.
Okay. Tiffany, what's your opinion?
Okay, so I was just about to say, I was reading a statement from the Pullman case. And the statement is, in finding attenuation, so we're discussing the crying and whether it's attenuated or not. In finding attenuation, the court explained that although prompted by Trooper Oliver, the handwritten statement was crafted by defendant without further involvement by the authorities. After defendant consumed the meal for about half an hour, Investigator Baldwin took him to his office, gave him Miranda warnings, and engaged in traditional intensive interrogation, recording defendant's admissions in a structured question and answer format. Under these circumstances, once Investigator Baldwin commenced his interrogation, a reasonable suspect in the defendant's position would have perceived a marked change in the tenor of his engagement with the police. So I think that supports, if I'm reading it correctly, I could be totally wrong, but I think it supports a finding that the moment that something happens, or like, let's say she was, arrested in her home or taken into custody and she did cry, as soon as questions start flowing, it changes the tenor of the moment, and that is an interrogation. Before she started crying, they asked her, "Why are you here? Or do you know why you're here?" To me, that she was in custody, and they asked her questions regarding the murder of the old woman, and that constituted a custodial interrogation in which she did not receive her Miranda rights in the beginning. Therefore, any statement received or obtained afterwards is now tainted by the un-Mirandized portion of the interrogation. And I think that if the police had just, and like I said in the last case, it says it in the police manual, that the first thing you're supposed to do when you're interrogating a suspect in custodial interrogation is to read them their Miranda warnings. And if the police had read them or read Panton her Miranda warnings initially when she was taken from the home, we wouldn't be here. We could have, avoided this whole thing. But because they didn't follow procedure 2 times, because they didn't arrest her, they didn't put the handcuffs on her. So 2 times they didn't follow procedure. And in one case, they're doing this procedure. They're following the procedures for recording. In one case, they're not. She was recording initially. She got her recording, I believe, quicker. Sparkle Daniel did not receive her recording. We have no evidence of what happened besides the statements made post or pre-recording. So I think that there's a serious issue here with the police following procedures. And if they did follow procedures, we wouldn't be here. And 2 murderers would possibly be in jail, or 2 murderers could possibly be walking free right now because they didn't follow procedures.
I completely agree with you. We shouldn't allow police that operate improperly to circumvent the Constitution and then be like, well, we're still going to convict the defendants. If the police officers did something incorrectly, we would rather allow guilty people to go free than allow police officers to stomp on the Constitution, in my opinion. And I think you're going for the same argument. They're required to give Miranda. If a police officer that follows their policies would give Miranda immediately, there would never be an issue that arises.
Agree. And then also the subjective and objective discussion we had in Sparkle Daniel's case is also relevant here, because the police who obtained someone under a false warrant take them from their home. Her children were obviously home. She didn't want to be arrested in front of her children. They took her to a lineup room. She's scared. They show her a picture in the record reflects. They showed her a picture of the dead old woman with a bag over her head. I mean, I would have cried. I mean, to be honest, I would have cried too. And they should have known objectively that by doing that, that could have elicited a statement that would have incriminated the person being interviewed.
The purpose of giving the photograph was to get her to incriminate herself. Right there before that photograph was given, Miranda should have been given, because what other purpose would they have of giving that picture? If they didn't believe she committed the crime, why are you showing her the picture? If you didn't want to get anything out of her, there's no reason to show her to her.
Exactly.
So I believe just showing her the picture alone, that enough is interrogation.
Exactly.
You, son?
As I mentioned earlier, that's kind of police kind of strategy and tactic to trigger defendant's kind of confession. So
is that something we want to condone?
So the photo shown to her kind of triggers her kind of triggers interrogation. So I totally agree with you.
But is that something we want to condone? And this one's faced a little bit towards Mark Catherine. Do we want to condone a police officers acting improperly when they blatantly disregard their manual, what they're supposed to do?
I wouldn't go so far to say that, no. I just don't think the only difference between what you think should have went on and what I think is okay here is one sentence. Do you know why you're here? I don't think if she was read the Miranda rights first and then the picture and then that question, I think she would have given the same exact statement. And the statement is what got her convicted, not her crying before that. So I'm torn because.
Does the sentence, do you know why you're here, elicit an interrogation-based question? Is that an interrogation-based question?
I guess it depends how it's said. It could be.
You're not going to ask a witness, do you know why you're here? You're only going to ask someone if you're trying to elicit information out of them, in my opinion.
Yes, I could agree with that.
Tiff?
I wanted to agree with you, San. I think the methods used here establish a pattern. So I think that even if we were on the fence about it being an interrogation, I think the similarities in how the defendants were taken, how they were brought to the same location, how they were not given their Miranda warnings until something happened, like something triggered that the officers thought might elicit a incriminating statement, then they read their Miranda warnings. I think it establishes a pattern. So if there was a question about whether it was an interrogation or not, or whether it was continuous, I think the likelihood of it being a pattern of how they investigate defendants is high.
It's a pattern of improper police conduct, is really what it is.
Exactly.
Caitlin?
I was going to say that I think it was in this one, too, that the police officer said that he had hoped that by showing her the picture, it would elicit an incriminating response. So if that's what you were trying to get out of it, if you would have just read her Miranda rights in the beginning, we wouldn't be sitting here. So I think that by the police knowing that what they were doing by showing the picture was going to elicit the response that they got, they should have read their Miranda rights then.
Okay. Chris?
Yeah, I definitely think it was a continuous chain.
How come?
Well, like I would say the warrant, I think they also mentioned that the officer admitted that he kind of used the warrant to hold her there. I don't think the crying obviously was enough to justify a break. And, I don't know, and then I also agree with you guys as far as the policy issues that it could present as far as police misconduct.
Okay, you, son?
Oh, I'm not sure if my memory is correct, but what I remember is detective kind of tactic was successful to Daniel. Thereafter, during the break, they went for Panton's interrogation room, and they did exactly the same with Panton. So that's why I think that's police tactic and strategy to trigger defendant's kind of confession and testimony.
Does anybody see an issue that the appellate division affirmed Panton's conviction and reversed Sparkles? Because that's something that perplexed me. Caitlin?
It bothers me, especially because the facts given in this case about Daniel's case are so much different, and had they used those facts in that way in that brief, I would have thought of a different like resolution, because they make the break in for dinner or whatever so much smaller in the Daniel's brief than they do in this brief. So I'm kind of confused as to why they didn't come to the same agreement here.
So what do you think they really based their opinion on? Because the main difference between the cases are that in Sparkle's case, she was given a longer break. And in this case, she was a shorter break, which was the only reason there was a break was because she was crying. Do you really think that had like a major concern in the appellate division?
I think it should have, but I don't think it did.
Okay. Let's see where we are. Hold on. Tiffany?
Okay, so I have a question for the group. I just want to make sure that I understand this language correctly. So I understand, because my understanding is this court did not come to the same conclusion because they were saying that the defendant did not preserve the issue for appeal. And I put the language in the chat that I got. The language of after the court's decision, counsel filed a statement of objections with 3 main points. Within the second point, counsel raised several issues. And this is the language I believe they used, was the defendant properly advised of her rights against self-incrimination by law enforcement officers, and did she understand her rights and thereafter knowingly and voluntarily waive those rights prior to making any statements? Is that's the language in contention, or no? That's the language that they're saying is not specific enough to preserve the issue.
Correct.
Okay, so I'm still in the same boat. I don't understand why they reached that conclusion when it walks like a duck, like you said, quacks like a duck. It's a duck. It's the same substantive issue or defense, and they totally gave it no weight.
Does anybody still believe that this issue is not preserved? Anyone? If you do, raise your hand, just so I know. Okay, so we got past that point. So then it completely also knocks out the other procedural issue of whether or not she ineffective assistance to counsel, because we never even have to touch that route because that was their alternative if it wasn't preserved. So let's take a vote. Where are we right now? Does anybody still believe that the appellate division should be affirmed? Catherine, did you finally jump sides?
I was swayed by your arguments. Only on the assumption that if they had read the Miranda rights before they asked that one question, I would be back to my old view, but they didn't.
Can you say that again? I'm sorry, I missed half your sentence.
I'm only switching sides on the assumption that if they had read the Miranda rights before that one single question, I still don't think the interrogation started until he asked that first question, that one question.
Which question?
Why are you here? Why do you think you're here?
But the picture you're okay with?
You can show a picture to someone in the street.
But what do you think the goal of the officer was in showing that photograph? What was he trying to do?
To say we know what you did. That's obvious.
So then wouldn't that be interrogation?
No, you could
What
do
are you
that
trying
before.
to get out of him?
You can show someone a picture before you have a warrant for their arrest. That's not an interrogation. That's a scare tactic they use all the time.
But you can interrogate someone before they're under arrest.
I don't think the picture is interrogation. I think the question was interrogation. And because the Miranda rights weren't read before the question, that's the reason I'm switching sides.
Okay. That's actually very similar to what happened with Sparkle the other day. There was that single question of, do you know why you're here? And I think that swayed actually most of us to the majority of that it was a continuous and it should have been Mirandized and they threw it all out. Does anybody see an issue with the prosecutor using the crying, even, okay, on the assumption that this we were to affirm, does anybody see an issue with the prosecutor using the crying in summation? Tiff?
So I believe, if I remember correctly, I knew a really good attorney, a med mal attorney in White Plains, and he focused on summation. He focused on it because he said it was one of the most powerful points in the argument to finally, sway the judge or the jury. So the fact that I'm not sure if it's a he or she, I don't remember, but if the fact that it was used in summation shows its power and its likelihood that it was, I don't know, it was likely that it would sway the judge or the jury. It was so powerful that he used it in summation. It's like the last breath that he had to make an argument, and he put that in there. So I think that shows that it was extremely incriminating, and that he used it in his most powerful or, strongest moment.
Jeff, what's your opinion?
That the crying should not have been used in the summation. I think that when you have a trial, the opening and closing are your most important parts. People tend to forget what's in the middle. And using that crying assumed guilt, and that's why they found her guilty, the jury. But I think that in this case, it should be disregarded and remanded for a new trial without the entire interrogation being involved.
If she was Mirandized prior to the picture and her crying, would you have been okay with them using it in summation then?
Oh yeah, absolutely. That's legal.
Okay, so then since we no longer have a minority, let's just go back to the top to make sure we hit we agree on all the issues. So we all agreed that the issue was preserved, correct? Does anybody disagree with that? Okay, and then we all agreed that this is a question of law, not a mixed question of law and fact that gives us jurisdiction because of the same reasoning we used on Tuesday, that we're stating as a matter of law that once a person is arrested, they should be Mirandized prior to any interrogation.
If I could, on the preservation issue, I think it might be helpful to all of you because I think some of you are doing a little bit of horse trading, which is perfectly fine, in that you're conceding one issue so that you can get to an answer that you're fine with on the other issue. Perfectly legitimate to do. But the problem that raises is it makes it harder for you. Like if you're not a true believer in the preservation issue, that's going to make it harder for you to write the majority if you choose to write on this case. So I think it would be helpful if you guys nailed down exactly what is the rationale for preservation of appeal and what was the authority that you found persuasive. Not that you have to use that in your opinion, but I think it might help everybody a little bit more as you get ready to write. And it occurs to me that it may bring out some disagreement that I think may be getting glossed over. If you want to gloss over it, that's perfectly fine, but I don't want you to do it on accident. So maybe talk about your rationale a little bit more and the authority to support.
All right, I'll reiterate my opinion because I actually felt the same way that everybody was glossing over it just to get to the substantive issue. I believe that since the co-defense counsel made the argument, even though it was in an unorthodox matter, that it should be upheld nonetheless, because from what I've studied, it doesn't need to be directly stating that this is why I'm objecting. It just needs to give the appearance that this is why they're objecting, and it can be done by co-counsel. Tiffany, I know you felt strong on this as well.
I do, and I have the same reasoning that you have. I'm actually trying to pull up the language in the appellant's brief and the authority that they use to support that argument. But I basically feel like I don't want to say I'm glossing over. I just feel like, I don't know. I just feel like it's form over substance kind of thing. I feel like they did preserve in the language. I mean, as a law student going out into the world, I don't want to put similar language into a brief and it's the same exact thing, but because it's worded a little differently or because the judge doesn't like it, it's like, boom, there you go. You know, I don't know, maybe I feel empathy for this new lawyer or whatever, but I just feel like he did his best using the language that he had to try to preserve the appeal, and the judge didn't give it a lot of weight.
Which is fine. If that's what you guys want to be your rationale, that's fine. But I think you need to establish whether or not you are departing from precedent, whether there is precedent that supports that position. Because all I've heard Kyle articulate is, I've learned that, and then your position, but I've yet to hear exactly what your authority is for this position, whereas I did hear some authority articulated for the contrary position. So I think maybe you want to nail down the basis for your position, the rationale for your decision. You've articulated kind of some policy rationales, but I'm still not hearing a lot of law.
My whole argument's policy. It is.
Well, okay, let me ask you this. So the rest of you, Kyle's about to take the law of the state of New York in a very different direction based on pure policy. Now, if you guys are down with that and you're fine with it, that's great. But this is an opinion that will make the New York Law Journal. This is an opinion that they'll go, whoa, if anybody in the room makes an objection, everybody in the room has preserved error. And so that's a departure. That's significant. That is significantly pro-defendant, which is fine if the court wants to be pro-defendant. But it reflects a departure, and I think you're going to have to articulate in the opinion why you are departing. You know, what is it about this case that is so compelling that you feel like the law no longer works? You don't want to just change the law willy-nilly. That's how the court begins to lose credibility. So you're really going to have to build this house if you're going to change the rule on preservation of error.
Tiff, were you raising your hand or just waving around?
I'm going back to the appellant's brief regarding the patent issue, and I don't think that, knowingly waived her right to self-determination. I feel like we didn't focus a lot on whether the defendant knowingly and willingly and intelligently waived her rights against self-incrimination before she made any statements to the district attorney. I kind of, like, Professor Norton's arguments are, I feel like, persuasive because there's an issue there. There's an issue of whether she knowingly and willingly and intelligently waived her rights against self-incrimination before she made the statements. So now I'm confused now. Now I don't.
Well, no, I'm not talking about the merits yet. I'm just talking about the preservation issue. Was it preserved at trial such that it can be raised? And if I caused you to doubt your substantive position, I didn't mean to. Although if it was that easy to unravel you on the second issue by attacking the first one, you may not be as committed as you think. So I just want you guys to be careful because you have a very strong Chief Justice who clearly has an agenda here. And you guys are just taking the path of, a lot of you are taking the path of least resistance. You're like, yeah, he seems to care about it a lot more than I do. So, yeah, let's go with that. But the problem is your chief is not articulating legal reasons. Your chief is about to take you to a path where you change the law and you just do it. And that's huge. That is news. That's news. When the Court of Appeals changes a rule like that without any analysis, just changes it. That's when you start getting calls for, they're legislating from the bench and they're activist judges. And I think without some legal foundation behind that preservation issue, I think it would be probably a fair charge. Now, I'm not saying you can't back it up. I'm just saying you haven't yet.
Okay, well, is anybody against me? We'll start there.
Listen to that.
I'm digging through the briefs.
And Kyle has fronted to you. I'm doing this purely on policy. I think the law is wrong. I get to change it, so that's what I'm doing. Okay? And so the question is, do you all want to go with him? Jeff is all, yeah. I'm in. Let's go.
I mean, I think that in the interest of justice also, it's not right that it says that on page 46, in her suppression hearing, the prosecutor addressed the Miranda facts with respect to both defendants. So if the prosecutor is going to address both defendants in an instant of this case, why can't co-counsel do the same? Despite the fact that it's not written in
Well, but there's
law
only one prosecutor.
But she addressed, it says the prosecutor addressed the Miranda facts with respect to both defendants. So she took the Daniel facts and these facts and addressed them both at the same time. So I think that if the prosecutor can address both defendants, then why can't
Because there's just one prosecutor.
Right, but she's addressing both cases at the same time.
She can say, here are these facts, because there's only one of her to say it. But if you're going to object, the question is, if one person says, Your Honor, that's improper to what the prosecutor said, are we to assume now that each counsel is now representing both defendants? Because this seems to have some implications, some professional responsibility implications also.
But don't you see the issue? I know this is another policy issue, but of judicial efficiency. And it's cited in the appellant's reply brief. Do we really want one co-defendant to be like, here's all this case law. Now we want the second co-defendant, I'm going to say the same thing again.
Shortcuts are always justified with efficiency. So, listen, I'm not weighing in either way. I know you think I am. I'm not weighing in either way. What I'm saying is, are you all comfortable answering one of these issues without yet articulating the law behind it? And again, I'm not saying you can't articulate the law behind it. I'm saying you haven't articulated the law behind it. So, I mean, if you guys are fine with that, then you can move on to the procedural issue. I mean, to the substantive issue, but it does seem like you went pretty gently on the preservation of error. Let me ask you, Catherine. Let me ask you. Tell us honestly, why did you flip on preservation?
I really think the one question that he asked had to be taken. Oh, with preservation?
Yeah.
I'm sorry. You know what? I'm reading more back now into the brief, and I'm kind of leaning back towards it's the attorney's job to bring up every single issue that they possibly can. Mm-hmm. The defense didn't ask the question or didn't even concentrate on the photo or the crying until it was on appeal, only focused in on the arrest itself. And I guess that attorney assumed that the arrest would encompass the photograph and whatever happened after the arrest. But I don't think it was brought up. And I'm not sure if it should be allowed to be brought up now.
So if somebody, for extra credit, wanted to dissent to this glossing of the preservation of appeal, your chief has articulated as his reason judicial efficiency. It's more efficient to let all the defendants rely on the objections of all the other defendants. It saves us time. But it seems to me like that cuts both ways, because it's judicially inefficient to let people appeal when they haven't preserved error. So now you've got 2 appeals for the price of 1, and that is judicially inefficient, because the whole thing about preservation of error is to preserve judicial efficiency. You don't get to run to the appellate court unless you've gone through all the steps. If you're not going to go through all the steps, that's going to help us weed out these appeals and keep the docket at a manageable place. So what you have done as the Court of Appeals, where you get to cherry pick your cases, is you said to the appellate division, listen, we're about to double your caseload. I don't want you to worry about it. We're basing it on policy. It's all going to be fine.
I have a change in my reasoning a little bit. I have an addition to my reasoning.
That's excellent.
Also, as the appellant's reply brief states, that in all of the papers that were filed, including the motions, the argument was made for suppression. So I believe it encompassed with the defendants, with the counsel's argument and the arguments made in the brief, that it was preserved. It's a double. Like, I'm not saying everybody gets to, you're automatically preserved. You actually have to elicit some argument towards it. And I believe that the argument placed in the motion does it for you, which I still know that's still pulling away from the traditional preservation of error law. But
well, you talk about the traditional preservation of error law like it's just, little flitty hoops to jump through. But isn't the hallmark of a preserved error that you got a ruling on it?
Yes.
So now you're saying, as long as I put it in my motion, I don't have to get a ruling on it.
But in this situation, they did get a ruling on it. When it's made by co-counsel, the judge does make a ruling. He's just making it for co-counsel.
Okay, so now you're getting somewhere. Now listen, now watch what happened. I've pressed him on his rationale, and this is what judges should be doing with each other. I pressed him on his rationale, and he's starting to develop it now into something that is worthwhile and defensible. Okay, it wasn't defensible, but now he's getting there. You're not quite there, but you're very, very close.
So as long as the argument is made by an attorney and it's the attorney himself makes the argument in some way and the judge makes a final determination on it, then I believe it's preserved. And I'm still basing it on policy.
Why? Why should it be preserved?
Well, first, it's judicial efficiency.
Well, how is it judicially efficient?
Well, why
throwing that around?
It's the easiest one.
How is it efficient?
Because you don't want a judge to sit there and make the same ruling twice. I've already ruled once. Why am I going to do it again on the same issue?
There you go.
It's res judicata. It really is.
But
almost.
It's a different party.
Yeah, sort of. I think that you're on to something as far as your rationale, though. I think you're definitely, it's not exactly res judicata, but you're on to something, that we do have mechanisms to not require judges to perform useless acts. That once they've made a decision, they don't have to keep making the decision over and over again. So I think there's something in there, and I think maybe a little bit of extra research I think will help you with that one. I think this is a dynamite decision to dissent from. I really do. I think you've got great grounds for so if any of you are bucking for the extra credit, I think you can dissent both on the preservation, because I think there have been great issues on preservation, and then I think you could dissent on the on the substance also. I think those would be great. Okay, so I'm going to leave you alone and let you move on.
Well, I think unless someone's changed their opinion, which I know Catherine was, or one of you were jumping back on the fence about the substantive issue of a continuous event, do we still have an issue there? Does anybody agree that we should, since we've gotten past the procedural issues, that we should uphold the appellate division's determination? So everybody agrees that we want to reverse the appellate division's determination. And no one sees the issue with an issue. Everyone agrees that this is a question of law, not a mixed question of law and fact. Tiffany, you have anything to say?
I'm kind of like stone cold. I'm exactly like Sparkle Daniel. I feel like it's the exact same case. I feel like it's not a question of law. I know we had an issue in that case regarding whether to discard it on procedural grounds, but here, I don't. Do you recall the exception?
The exception is that the record does not support the holding of the appellate division.
So I don't think the exception applies here because the record.
Do you think it is mixed or it's not mixed?
I think it's not mixed. I think it's a question of law, but I was trying to articulate whether why the exception doesn't apply. Because if the exception applied, it would be, stop me if I'm wrong, but I believe if the exception applied, it would be considered a mixed question of law or fact.
Correct.
Okay, so
you have to say that it is a mixed question to get to the exception, because it's an exception to that application.
Exactly. So I'm a little hung up then on whether it's a mixed question of law or fact. Now that I go back to the Sparkle Daniel case, because the facts here, I mean, it's different facts. The Sparkle Daniel case, the record, it's definitely, to me, or to us, it was definitely a question of law. The record did not, the record supported, I believe it was, or no, we decided it was a question of law, so we didn't have to get there. But I think here, because the facts are so different, that an argument can be made that the facts do support the appellate court's finding.
That it's a mixed question, so it should have been dismissed?
Yeah.
If we go down that route, though, is the exception satisfied for us to make a ruling to give us jurisdiction?
That's where I'm hung up.
Well, do you think the record, from the record alone, that the interrogation was continuous, or do you believe that the record could not have shown that to the appellate division?
No, I think the record supports that it was continuous. I think it's 100%.
Well, then your exception would be satisfied, because that's not what they did. Because they threw it out on the preservation issue, which no one wants to argue with me about. So,
can I stew a little bit longer? Because now I'm just like going over the facts in my head and just making sure that I understand why I'm holding the way I'm holding.
Sure, we'll harass Jeff.
Yeah, let me stew a little bit longer.
Jeff, because you were on my side too, what's your opinion? Do you believe that this is a mixed question, or is it a question of law? After Tiffany's change of heart a little bit.
No, I still think it's a question of law. Just it comes down to whether or not she was Mirandized, and she wasn't. And I don't really.
Well, you weren't here, but because of our holding in Sparkle the other day, I think that this makes it clear that this is a question of law, because we're stating when a person needs to be Mirandized. We're stating that upon arrest and before the police even talk to you, you need to be immediately Mirandized. That's the law issue we're answering, which was kind of the same law issue we answered in Daniel Sparkle to get past this issue. What's your opinion on that? Do you think that we should decide that as a matter of law?
Yeah, absolutely.
Why?
Because otherwise, like, Miranda wouldn't exist if it wasn't a matter of law.
Catherine?
I think I agree with that. I mean, that is the issue. Was she Mirandized at the right point in time?
As a matter of law.
It's a matter of law.
Do you
So
think
the issue for me was, when did the interrogation start? Because as a matter of law, she should be Mirandized before she's interrogated.
Okay. Alyssa?
I still think it's a matter of law issue just because of the Sparkle Daniel case and just essentially what we've been saying about the Miranda. It's just a question of law. I haven't changed my mind on it.
Melissa?
Same as last time. It's the same situation. We asking the same question, whether when she should have been Mirandized. So for me, it's an issue of law.
Caitlin?
I still agree with that it's an issue of law solely because she should have been Mirandized once she was taken into custody.
Yusan?
I didn't decide it yet.
Okay.
Even though I strongly believe she should, should be, Miranda warning should be given to her immediately when she was in custody. I'm kind of confused with it's question of law and a mixed question of law and fact.
Do you think it's a mixed question?
I'm not sure because very very similar to Daniel.
Okay.
So.
And in Daniel, we held it was not a mixed question. We held it was a question as a matter of law. Remember, we made a determination that.
Oh, yeah. And at the time, you said exception is inapplicable, right? At the time, regarding Daniel. Could you repeat what is the exception?
The exception. So the issue is, if it's a mixed question of fact and law, the only way the appellate division, the Court of Appeals, can hear the issue is if the record does not support the finding of the appellate division.
Oh, okay. Then it's clear. It's question of law, and exception is inapplicable here, I think.
Yes. If you agree that it's a question of law, you don't even get to the exception because it's unnecessary.
All right. Mm-hmm.
Chris?
Yeah, I think it's a question of law. I probably have more of an issue with whether it's preserved, but I'm gonna, agree with you guys on that one. I contended. So
You can come against us. It's okay if you don't agree with it.
I don't know. I'll just save it for extra credit.
For your dissent? Okay. Tiffany, we let you stew, so.
Okay, so I'm going to go with it's a question of law and not a mixed question of law and fact.
How come?
For the same reasons that we found in the Sparkle Daniel case, the exception does not support the appellate court holding that the judgment should not, and I'm really confused with this mixed question. The more we say it, the more confused I get. I don't know why. I thought I was getting it, but I feel like the appellate's court's decision is not supported or is not supported by the facts.
Well, if you're saying it's a question of law, we don't have to get to that. That's the exception that if it was a mixed question.
Okay, so I'm finding that it's a question of law because she should have been Mirandized as soon as she was placed. It was the same issue in the Sparkle Daniel case. I believe she should have been Mirandized as soon as she was placed in custody and asked a question. I mean, I remember Jacqueline stating that she wanted to narrow it, so I kind of feel like we should narrow it in this case also and find that we are narrowing it to these facts. Like, it's a question of law regarding, if somebody should be Mirandized upon custodial interrogation.
After arrest.
After arrest, exactly. So, okay, I stewed. I'm done stewing.
Catherine?
I'm just back on this procedural issue.
Which one?
Whether the issue was expressly decided.
So on the
As a
preservation
matter of
issue.
law, I guess, was the issue already decided that is now being raised on appeal? Because I'm just reading through the both briefs again, and I don't know. I don't think it was.
You don't think what was? I'm sorry.
I don't think it is preserved.
Okay, so the other procedural issue.
Yeah.
Why do you think it's not preserved?
Just the more I'm reading. I mean, I guess your view would be it was expressly decided because the issue brought up by co-counsel encompassed or incorporated what we're bringing on appeal. Whereas if I write the dissent, I'm going to argue that it wasn't encompassed. It should have been brought up separately, specifically regarding the picture, because it wasn't referenced in the initial defense argument. It was more centered around the arrest.
No, I agree. This is actually a very strong case to write a dissent, because if everyone's just agreeing with me, we're basing this all on policy and not on law at all. While your dissent can be entirely law. Right now I'm pulling a Scalia, which I'm not very happy about. And your dissent can just be, this is what the law states, and we don't agree with the policy, that direction you're choosing. But I think we have like 10 minutes left. So let's get through and see what our majority is for everything, just so we know for writing the opinion. So for the issue of preservation, and if anyone disagrees with me, just stop me. We can go over it again. I believe that we're heading in the track of, as a matter of policy, we're stating that it's preserved because the argument was made in his papers, and the argument was made by co-counsel, and the judge already made a determination on this. On the issue of a matter of a mixed question of fact or law, we're stating that we're trying to make this ruling as a matter of law, that once a person is arrested and placed in custody, it is automatically a custodial interrogation, and they should have been given Miranda immediately. And then it brings you to the last issue, that it's continuous because of the applying the factors that were cited in the briefs, that it was continuous because there was no break, the same people, she was never taken out of the room, and that the inactive crying did not interrupt the continuous interrogation because it was done for the purposes of eliciting a incriminating statement. Yes, Catherine?
I'm sorry. This might have been answered on the first day, last class. If this is what we're agreeing on as a class, we choose to write about this case, we have to write based on what we all agreed upon, or can we still pick any side?
No, you still have to write about what's agreed upon.
Okay.
But then you can do as extra credit your concurrence or dissent.
Okay, thank you.
Mm-hmm. Tiff?
All right, so I'm rereading the respondent's brief, and it says here their issue was, at the pretrial hearing, defendant's focus was on claiming that her statement should be suppressed because she was threatened into waiving her rights, and also because the statements were not attenuated from the patent violation allegedly committed by the detectives. So wouldn't that support a finding that the issue wasn't preserved? If she's now saying that the issue was she didn't receive her Miranda rights initially, but they argued that their main argument was that she was threatened into waiving her rights, then I would say then the issue wasn't preserved.
Well, I think the issue of preservation wasn't what occurred in the police station. It's what occurred in the courthouse. She wasn't threatened at that point, but then from the record shows that the attorneys did make the argument during court, and then it wasn't a motion. She may have been threatened into waiving Miranda at the police station, but that's besides the point, because the attorney, it was still brought up in the attorney's papers and by the other defendant's counsel, that's where you have to preserve. We don't care about what happened in jail for that purpose, in my opinion.
So they weren't trying to say that it was the fruit of an illegal arrest and that it was because she was threatened, because that's where I'm hung up on, because if they were arguing that, if they were making argument A and then probably saw Sparkle Daniel got a decision on, reason B, and then they tried to argue reason B because Sparkle Daniel won, then I have an issue.
It was actually a joint suppression hearing. It was done with both defendants before the same judge. That's my whole issue with this. If this was two separate independent hearings, my policy argument would be gone. But because it was a joint suppression hearing.
Does it bother anybody, though, that they were arguing that it was the fruits of an illegal arrest and that that they were trying to say that she was threatened instead of, does that hold any weight with anyone? I don't know. It's like weighing heavy on me.
Catherine?
Yeah, Tiffany, and that's where I was kind of going when I was just reading back on it. It seems like the crux of their argument initially was that she was coerced. And that's why she waived her rights, because she was threatened.
Yeah.
Not because...
argue something else.
Yeah, it seems like a completely different argument.
So I think that for the preservation issue, I'm not in.
Okay. I do understand where you're coming from, but I still like my policy. So that's why I'm still on the side that I'm on, because I'm very pro-defense. And if the police did something improper, we should not be condoning improper behavior. And we were on point with that earlier.
We also want to support ethical conduct of lawyers and them performing their jobs, in the best interest of their client. We also want to promote lawyer competence, So,
but the argument was correctly made in his motion.
I think I'm over to the dark side with Catherine.
You don't like my motion argument? It was made in the motion.
But the motion is after the decision. That's the whole issue.
Yes.
Yeah.
Okay, so right now we have two stating that it's unpreserved. What do the rest of you guys believe? If anyone else agrees with them, just raise your hand so I can count. Okay, so we only have two. So I guess Chris? Chris, were you agreeing because you raised your hand?
Yeah, I agree with the other two.
For what reason?
So their argument basically is, yes, it was in the motion, but it was after the judge had already made the decision. Is that what you're saying? Yeah. So you can't use the judge's decision. The judge's decision couldn't have applied to the request because the request wasn't made at the time that the judge ruled on it.
Yes, that's where I was going.
So, Chris, you're on board with them with that reasoning?
Yeah.
Okay, so that gives us three people stating that it's unpreserved. Does anybody else agree with that? All right, so it is a minority of people that believe that it's unpreserved. So there's still it's a 6-3 on that.
Now, let me make a suggestion for those of you who might consider writing the dissent, that you think about when you're thinking about making things easier for yourself. If you're inclined, especially Tiffany and Catherine, to write a dissent on this, think about writing the majority too. Because you're already going to have to do the research and go back to the briefs and work with the briefs to write your dissent. So why not get double duty out of that work and write the majority also? I promise you that both your majority opinion and your dissenting opinion will be stronger for having had to write them both. that it will strengthen your arguments for having to write them both. Now, conceptually, obviously, a judge can't sign the majority and a dissent in the same case, so we're just not going to worry about that. Okay, we're just not going to worry about it. For each opinion that if you choose to write the majority and the dissent, for each opinion as you write it, just write it as if that's the only opinion that you're writing. Okay. Any questions either about this one or Sparkle Daniel? Okay, fantastic. So we are not meeting again until next Thursday. We're off for July 4th, and then the Monday, Wednesday classes meet on Tuesday and Wednesday of next week. So we meet again next Thursday, July the 7th. Yeah, we're going to meet July the 7th to take up the first civil case. I had it right here. The first civil case, which is Park. And we have presiding Justice Mandela on deck for that one. So, okay, have a great 4th of July weekend. Be safe, be happy, and I'll see you guys a week from tonight. Great job.